when people are separating, what happens to credit card debts? Like loans, it seems a little bit more obvious because like a loan is normally attached to a property, a house, or maybe a car. So I feel like people kind of understand that a little bit better, and they understand that if you're going to put the house in the property pool, then the loan that's attached to it's also going to come into the property pool as well. But when it comes to things like credit card debts or maybe like HEX loans, where it feels very attached to a particular person as opposed to something that was joint, then I think there's not a lot of clarity around that, and people don't really think about it, especially when they're in the relationships and one person could be spending a lot of money on their credit cards, racking up big credit card bills, and the other partner might think, well, that credit card's in their name, I'm okay, I'm protected from it. But that might not be the case in a lot of scenarios, and it might catch a lot of people off guard.
A lot of our clients would like to just look at the positive value assets, but then there is a lot of debts that are associated. The good thing about the amendments that we've had in the Family Law and the Family Law Act as of May this year is we now have specific sections within Section 79 of the Act which deal with wastage, which deals with the question of where did the liabilities come from? Because they've got this feeling, or they've been told by a friend or family member, or they should be entitled to something more, becomes that issue that, look, I don't want to settle this, I don't want to sign this, or I want to withdraw my consent. The other one could be that a lot of the time, and it happens more so in a parenting context than property law context, is, well, I've spoken to my child about this, and my child doesn't want to comply with the order, but the child's 5. And first,
it's like, what other major life decisions do you leave up to your child who's 5 years old? If your child says he doesn't want to brush his teeth, are you going to leave that up to the child? So Harpreet, thanks for joining us on the show. One of the best family lawyers that we have across our network, one of the best family lawyers that we have in Sydney. Your experience across the board, all different types of family law matters, is astounding. But particularly, I think one of your key strengths is dealing with property law matters. So please break it down for us. What is a property law matter in the context of family law? And how do you even define property? Because I think it can be such a broad kind of topic, and we've had lots of questions as to whether or not it includes things like superannuation, the family dog, the rug on your living room floor. What does it mean to you in terms of property, and can you break that down for us?
Thank you for having me, Heda, and thank you for that introduction. Property law, in essence, just include whenever there's a separation, whether it's a de facto separation or a marriage breaking down, if parties are unable to decide how their assets and liabilities should be split, they come to someone like myself, Justice Family Lawyers, and then they ask for assistance in relation to how to go about that process. When you're going through a separation, you've got property side of things, you've got parenting side of things if you've got children, then you've got a divorce if you're married, and then with the recent amendments in the Family Law Act, you've also got companion animals that now fall within the umbrella of property settlement, and there's specific clauses in our legislation that now deals with the dreaded question as to what happens to the pet. So when you're talking about property settlement, you've got basically anything that has got a value attached to it, whether it's a positive or negative value. You've got things like, matrimonial home, you've got savings, you've got shares, you've got motor vehicles, superannuation. As long as one of the parties or both of them are tied to it, it all forms part of the property law, property settlement umbrella within the context of family law.
You mentioned something quite interesting that I think people don't normally think about, which is it could have a positive value, but it could also have a negative value. And I think that's something that often gets overlooked or not really thought about when people are separating. What happens to credit card debts? What happens to, like, loans? It seems a little bit more obvious because, like, a loan is normally attached to a property, a house, or maybe a car. So I feel like people kind of understand that a little bit better, and they understand that, if you're going to put the house in the property pool, then the loan that's attached to it's also going to come into the property pool as well. But when it comes to things like credit card debts or maybe like HEX loans, where it feels very attached to a particular person as opposed to something that was joint, then I think there's not a lot of clarity around that, and people don't really think about it, especially when they're in the relationships and one person could be spending a lot of money on their credit cards, racking up big credit card bills, and the other partner might think, well, that credit card's in their name, I'm okay, I'm protected from it. But that might not be the case in a lot of scenarios, and it might catch a lot of people off guard.
And that's actually very, very true and correct in relation to a lot of the inquiries we get and a lot of the clients that we actually have. They lay people, they don't necessarily understand that when you look at the broad umbrella under which the family law property settlement falls into, a lot of the time the questions are in relation to, well, look, I've got a property worth, $1 million and I would like to get blah percentage of it. But then when you start looking at the nitty gritty of it and you start going through what the asset pool is made of, you realize that the $1 million property actually has a big mortgage attached to it. A little bit more convoluted example in this scenario is obviously if a party's got a business that they control or a company that they run, a very common misconception and very common question that we get asked as part of the settlement process is, well, look, the company owns a car, the company owns a brand new vehicle that is registered in the company's name. But then you can't isolate that asset and then just ask for a share of that. When you look at companies or businesses, you have to holistically get it valued. And then that motor vehicle or the inventory or this investment property for a lot of self-managed super funds, they fall within the context of what the business does and what their assets and liabilities are. And there might be loans attached to it further down as well. So it is very true. A lot of the time, a lot of our clients would like to just look at the positive value assets, but then there is a lot of debts that are associated. The good thing about the amendments that we've had in the Family Law and the Family Law Act as of May this year is we now have specific sections within Section 79 of the Act, which deals with wastage, which deals with the question of where did the liabilities come from. We didn't have that before the recent amendments, because if there was an argument in relation to a liability being accrued, for example, somebody going and taking a loan and then using those funds to gamble it away, the party who wanted to actually raise that as a concern had to specifically run that as an argument under wastage. But now with the recent amendment, we've got specific clauses that the court has to, sections of the Act that court has to consider as they go through the different steps as to what the debts are, when they were accrued, what the purpose of those debts were, and so forth. So I think it's getting a lot more streamlined in relation to a lot of people going through this process, especially where there's concerns about spending positive value assets or mortgaging them to reduce the asset pool. So I think it's a step in the right direction.
Yeah, I can think of some cases where we've had clients come in and they thought they would be receiving, large property settlements because they might have lived a certain lifestyle, nice cars, maybe a boat, beautiful big house, business that seemed to be operating okay because they were living this kind of lavish lifestyle. But once we dug down into it, we didn't realize that all of this was funded heavily by debt. There were creditors coming after these people and trying to get that debt back. And what we thought was an initial large asset pool might not have been as large as what the parties thought they actually had once you took into account all of these debts. So it can be quite deceiving, especially, in this day and age. People want to live that luxurious lifestyle and that outward lifestyle, but once you look under the books, it might not follow.
And I think it rings true in relation to obviously what we do within the context of family law, in a sense that obviously you want all your clients to actually have a good outcome where they're able to obviously sustain themselves moving forward. But a lot of the time, the problem is in relation to the life that they've been living or they've been led to believe that they were able to live for the last 5, 10, 15, 20 years, they don't necessarily quantify or equate to them being able to continue having that lifestyle into the future as well. Precisely for this point that you've raised, that a lot of the time people are able to have these lifestyles if they don't have significant cash reserves purely by the mechanism of how they ran the business and by saving the money from the taxman. But as soon as there's a separation and then there's the forensic accounting of those bank statements or the accounts or the businesses, you end up having this massive tax debt that was not being paid for the last 10 years. And all of a sudden, it is something that is going to be owed to third parties. So it's difficult for people to, in that scenario, understand and appreciate that it is a matrimonial debt. Unfortunately, that is going to be on the balance sheet in relation to what the parties are going to be dividing.
Let's break it down a little bit further because it might be a little bit confusing to understand. So let's put it into a scenario, I guess. So if if a couple's living together and they've been running a business and the ATO is coming after them because they haven't done their tax returns, just like what you said, for the last 5 years, and there could be a couple of $100,000 or maybe $1 million in debt, that wouldn't be strange. That'd be quite like ordinary if you haven't been keeping up to date with your tax returns and things. Now, what you would often hear is one person saying, "Hey, but I didn't know that we weren't paying the taxes. I didn't know this. I thought they were getting paid. Like, I'm here and that wasn't my duty in the business, or that I wasn't involved in the business. I didn't see the finances. I didn't know I wasn't being paid. And so in that situation, can you plead ignorance when it comes to those debts?
I think one of the key principles in our family law system is it's not about finding fault or attributing fault in relation to why certain things happen in your relationship when you were living with someone for X number of years. The crux of the argument in relation to when there is such a hidden debt that comes to surface after a number of years is basically around what benefit the parties as a matrimonial unit received from that those choices. And the most common one is not necessarily the ATO coming after the parties themselves. It does happen. We've very famously had a case not long ago where the ATO was owed a lot of money. I think it was close to $1 million in unpaid tax. And they ended up joining these proceedings. And then there was very little left for the parties to actually divide among themselves. But in relation to whether a party can plead ignorance, it actually comes down to who received the benefit and how it was actually spent. And if the parties as a matrimonial unit, as a family unit, receive the benefit of it, it's very hard to then attribute the blame or the debt specifically to one party. It can happen depending on the circumstances of the case, but it's very, very hard to run as a standard argument, if that makes sense.
So when it comes to, splitting the assets, we often hear, or we often got a lot of questions of people asking, how can they hide their assets so that they're not part of the separation, they're not part of the split, because they're trying to withhold that. And you and I know that can be quite, it's almost impossible to kind of hide assets. But what might be a little bit easier would be to drum up a large amount of debts. And we've definitely seen that in recent years where there has been a large amount of debt accumulated. And I think that's why we've gone to these family law amendments and included, like what you said, in terms of the wastage stuff in Section 79. So it's included in the overall split as opposed to an afterthought, let's say. And the ability to drum up those debts and having the other party then try and trawl through and figure out what are real debts, what are not real debts, that's definitely been an issue that we've seen. And I think that's why they've tried to address it in the Section 79 amendments. What do you think?
I think that's precisely one of the reasons why we needed these amendments. I think there was also this massive epidemic, in my view, that we in Australia as a society are facing around domestic violence and how that's getting out of control. A lot of time people, especially the cases that we dealing with, unfortunately has an element of domestic violence attached to it. And what people don't realize that domestic violence is not necessarily just physical abuse. A lot of the time this is in relation to people being exposed to financial abuse. And part of the financial abuse is racking up those debts. And a lot of the time they are manufactured debts where they didn't exist, especially when parties have got complex financial structures or semi-complex financial structures where there's trusts and companies and so forth that exist, where if you look at the company's finances as of a couple of years ago, it had no significant debts. And then in lead up to the separation or shortly after separation, you have this massive debt owed to Uncle John. And that is disclosed in the company's finances. So it is something that we do see happening more and more, I think, in the cases that, especially that end up getting litigated. And I think a lot of the time people are trying to use that as an excuse for not entering into any kind of split, because they're saying, well, if you're going to split, you have to take on my debts as well. And secondly, to try and frustrate the process as well. And I think the amendments were made precisely to try and curb those kind of cases.
We had a matter where there was a cafe that was owned by the couple. It was actually purchased about 2 years before they separated, and they purchased it for about $100,000. Then by the time it got revalued, the husband was running the cafe, and when it got revalued for $40,000, and this is 2 years later. Now, the wife was arguing that this is not the real income that was being shown to the valuer, and was trying to go through all of the income statements and the bank statements showing that a lot of the expenses were actually not expenses of the business. And we're talking about a small business here because, it's just a local cafe. We're not talking about a large multinational company. And we're not talking about a crazy amount of money in terms of valuation. It's a lot of money for these people, but that $60,000 valuation difference, in order to kind of get that back in terms of like the financial accounting exercise of it, trying to figure out what were real expenses, what were not, dealing with a valuer, maybe a forensic accountant to kind of go through all of that. It's a nightmare, especially for these small businesses, and the amount of effort and the cost to kind of argue such a valuation which is really a result of fake expenses or fake debts, it really outweighs the exercise of trying to make the argument in the first place. Is there anything that can be done in these situations?
I think one very interesting thing that you raised is there's always that also confusion in relation to what's the true income of a business as compared to what its value is. A lot of the time, these transactions or these efforts that are made are to reduce the value of the business. And in this example, the cafe might not actually have any value in itself apart from the location, depending on the lease, how long is on the lease and what kind of inventory you've got. But the issue, what a lot of time people don't understand, is that you might not have any value in an asset per se, but it might still be a relevant, say, future needs argument in relation to a financial resource or produce a lot more income. So when people do go down the path of obviously dealing with cases where you've got smallish asset pool, and then it's not worth dealing with a forensic accountant or a valuer, which I absolutely appreciate could be very off-putting in relation to how expensive those exercises could get, is approach your accountants, speak to your accountants. They might be able to give you a very high level explanation or understanding in relation to what the estimated value of the business could be. And then it's more of risk versus reward of assessment. And, you don't want to be throwing good money after bad, but it might give you a fairly good basis of deciding whether it's worth pursuing going down the path of the family law valuations, or whether it's something you simply run as an argument to seek an adjustment. So it's a case-by-case analysis, I guess, in a situation like this. But I absolutely appreciate that it's very difficult to come up with those decisions when you've got a small business and you don't have significant net assets that you're fighting over. So it's always a tricky decision to make for the clients.
Can you think of a case where you were having such a large dispute over the valuation of a business or any particular asset, and that's what was like the key holdup in a case?
Unfortunately, I think it's tied into pretty much any complex family law matter that you end up litigating over. There's almost always a dispute in relation to what the true value of a business is. For example, real estate, not so much, because I think real estate, it's so much easier to get valued and obviously a lot cheaper to get it valued as well. But I'm currently acting in a case where there's significant disputes in relation to what the true value of the business is. Are there a number of entities? A lot of them are independent entities in themselves, but then a lot of them are actually interrelated entities. And they've been set up to run a particular business or make a particular investment, but then the subsequent sub-entities are more to deal with tax avoidance and distribute dividends and so forth. Now, if you try and one of the issues we've got in that case is if you try and value the main businesses in itself, you can't do it until unless there are tax documents and financial statements updated and lodged with the ATO. A lot of the time, in this case, for example, you don't have up-to-date records that have been lodged with the ATO. So we've got 2021, 2022, 2023 finances. If you then proceed to get those businesses valued, the problem you're going to have is by the time you go to a hearing, there's an argument of those valuations being out of date, regardless of when they're prepared, because it's from 2022 to 2023 financial year. But more so, if it takes 12 months for the matter to go to a final hearing, you're going to have to update those to bring it up to standard as well, which adds to the costs in a situation like this. So in this case, where we are at the moment is we've just received orders for there to be valuation, received orders for there to be information provided to the valuer, and ultimately, depending on what information is provided, you'll just have to make a decision as to whether you proceed with getting the business value based on the information you have, or whether you go back to court and get for some further disclosure around that. But it's always tricky.
And so if you do get a valuation and you're not happy with it, what are your options in that situation?
The family law rules, and again, this is something a lot of clients and lay people don't actually understand. And the questions in relation to if there's a valuation, there's always, in my practice, I've always seen one of the parties are not going to be happy with what's in the valuation and they will want to challenge it. There's a difference between challenging a valuation as compared to asking the expert to provide clarifications as to how they got to the valuation or what the valuation actually means. So when you talk about challenging the valuation, it's not the most straightforward or streamlined process under our family law legislation, simply because the courts don't want a party in a matter that's not happy with the valuation to just reopen the case and then adduce further evidence in relation to those valuations. A lot of the time, what people would want to do, what clients would want to do is, well, we've received the valuation. I don't like it, what's in there. I want to go and get my own valuation. Our rules don't allow for that to happen. We only have single experts that the parties can jointly retain. There's ways of asking questions, seeking clarifications, and even challenging those valuations. But you have to do it within the confines of what's allowed, which is by asking questions from the valuers, providing relevant material. If, for example, there's a comparison made in relation to a property, providing comparative sales that have not been included in the valuation by the valuer, and asking them question as to why that specific comparative sale was excluded. Ultimately, if you do believe that a valuer has got genuinely wrong, it comes down to asking questions under cross-examination, but unfortunately that can only happen at a final hearing. So there are ways of dealing with that issue, but then it's not as simple as going and getting your own valuation and then being able to rely on it at a final hearing or in court, generally speaking.
Yeah, so what are the common arguments that people would use in order to dispute a valuation, whether it's for a property or for a business? If you get a value and you're not happy with it, like you said, probably happens half of the time for half of the people because they're either expecting it to be higher or lower. What can you actually argue? Can you just say to the valuer, look, I'm not happy with it? Obviously, you need to provide some kind of evidence, but are there certain grounds or kind of criteria that you can kind of follow in order to make sure that you're a little bit more successful? And have you seen it happen in success where a professional single expert, has been able to reduce or increase their valuation as a result of arguments put forward by a lawyer, barrister, or client?
I don't think in my practice I've come across a scenario where questions were asked from a valuer because there was some doubts in relation to what was included in the valuation, and then them going and changing the valuation report purely based on the questions. I recall there was one case where I think it was during the COVID time where the valuer was actually very sick with COVID, but they had this deadline they had to meet to prepare this valuation, but they had obvious things wrong in the valuation, where we were able to write back to the valuer and say, hey, you've got the wrong property address, or you've got the wrong layout, or the land size. And in that case, the valuer was able to obviously correct that report and apologize for the oversight, and then they were able to update the valuation. The more common scenario that ends up happening is you ask the question pursuant to the rules, you ask for clarifications, you provide comparative analysis of what you believe or your client believes it should have been considered in the valuation report. It's difficult for single experts, whether they're property valuers or business valuers, it's difficult for them to actually come back and then change their opinion simply because somebody's asked them questions, because that kind of makes it difficult for their professional opinion to hold the scrutiny of the court. But more so unless there's something inherently wrong with their analogy or the methodology or the facts that they've relied upon, because at the end of the day, they are providing an opinion to the court, and then the opinion is their personal opinion. So in circumstances where a valuer has been asked to amend their opinion or provide evidence in relation to their opinion, it generally happens under cross-examination, where you're asked questions at the final hearing, and then you actually have to explain how certain things were concluded in your report. And if there is flaws in the valuation, if I can call it that, and there might not be obvious flaws in relation to getting the land size wrong or the business turnover wrong, it's more about challenging the opinion of the expert in relation to, hey, look, you've reached this conclusion, you had this another potential conclusion you could have reached. Do you change your opinion? And then it comes down to obviously how confident that valuer is in relation to providing their evidence and their opinion, and whether they're going to alter their opinion or not. Just one other thing that actually a lot of people don't realize is valuations and whether they're property valuations or business valuations, they almost always come with a time frame attached to it, that valuation or opinion is only valid for a certain finite amount of period. For property valuations, for example, a lot of them are only valid for a period of 3 months. Some business valuations might have a longer period attached to it. And the significance of that is a client might receive a valuation today, but if their hearing is not in, or their mediation or whatever the next significant event is, it's not in the near future, within that time frames, within those caveats, you are going to go and get an updated valuation report, which you almost always end up doing. It might not be a new report, it might just be an addendum to the report that has been prepared. And that provides you an opportunity to adduce this new evidence, if you believe, that has come into existence, or provide new letter of instructions in relation to what needs to be considered in that valuation. So as I always say to my clients, obviously, even though we're not professional valuers or accountants, you get a fairly good sense of how these reports are written and whether there's something inherently wrong in the way the report is written. And then it just comes down to obviously what's the best course to address that, whether that be through getting your own expert, seeking the court's leave to rely on that, or getting addendums done, or asking questions and so forth.
Well, hopefully your matter doesn't proceed to that part where you're at a trial and you're pushing a single expert to get you to make concessions that might suit your case. And hopefully you've done your best to try and settle your dispute prior to that, which I know you do a lot of the times before going to trial if there are things that we're uncertain about, or even if you think that it'll be in the best interest of the client, you're going to be pushing them to settle and pursue some settlement discussions and negotiations. So I'm curious, what kind of things have you seen gone wrong in the midst of those settlement discussions that just seemed absolutely absurd to you as to why we can't settle or we can't come to an agreement and then have to take the next step, which is going to trial?
As my mentor, shout out to Ash Kalmath, he always said, in working with any good barrister, they always say, look, trial litigation should always be a last step. And I've always tried to explain that to my clients right off the offset. And the reason for that is not only it's expensive and it takes time, but you kind of lose control over the process once the matters end up in court. Now, obviously, there are certain matters, and we'll talk about some examples in relation to what you've asked me, where you have to go to litigation, you have to actually start court proceedings and potentially go to trial as well. But if there is any potential of settling this matter, that should always be the first step that every party should take. That's actually embedded in our practice directions from the courts that I issued as well, that every party is required to make every reasonable attempt to settle the matter at every opportunity they get. In relation to specifically to the examples, I can think a couple right off the top of my head where if a party, and it's actually I think it applies on a much more broad brush approach in relation to the clients that we actually end up getting. A lot of the time, if people believe that they're not being heard, or if they're being undone with, and the law might say a certain thing, but obviously if you look at the facts and if you actually look at what has actually happened in a relationship, they might not be looking at it from a legal point of view, from how the law actually dictates what should happen. And then in that situation, if people feel that they're not being heard or they're being undone with, it actually becomes very hard to actually get them to see reason around why it might be in their best interest to settle this matter rather than having to commence proceedings. A lot of time in those situations, and I've been at both ends in this example, where your client, you would have a deal done, you would actually have settlement terms agreed upon, but a client had one night, two night, and then the buyer's remorse sets in, and then they want to pull out of pull out of the deal. And at that time, unless there's a legal basis behind that rationale, they'll start making excuses in relation to, oh, look, I spoke to my mum and my mum said, I should be entitled to a lot more. Or, well, my friend went through the same process and then my friend's lawyers were able to get them beautiful outcome as compared to this. And then you have to obviously try and explain to your clients again that every case under family law umbrella and the way our family law actually works is very unique, and there's no one shoe fits all in this scenario. And they might have other friends or family members who might have gone through a similar experience, but they might have completely different facts. So simply because they've got this feeling, or they've been told by a friend or family member or colleague that, look, they should be entitled to something more, becomes that issue that, look, I don't want to settle this, I don't want to sign this, or I want to withdraw my consent. The other one could be that a lot of the time, and it happens more so in a parenting context than property law context, is, well, I've spoken to my child about this, and my child doesn't want to comply with these orders. But the child's 5. And firstly,
It's like, what other major life decisions do you leave up to your child who's 5 years old? If the child says he doesn't want to brush his teeth, are you going to leave that up to the child?
Now, look, if the child was anything like my child or myself when I was a child, I didn't want to go to school. I hated going to school. And if my mom and dad just let me do what I wanted to do, I obviously wouldn't be doing this at this moment. So there's a lot of decisions that obviously I absolutely understand. And being a parent myself, I do sympathize and appreciate where a lot of these parents come from. Because money-wise, I've always felt that there is that transaction attached to it for a lot of clients, that it's, it's money, go through this process rather than paying lawyers hundreds of thousands of dollars. We'll try and keep that in our pocket. But with parenting, it's difficult because that is the biggest investment you make. It's your child. And it's a lot of the time, in a lot of these cases, it's very hard for parents to actually bring themselves up to that realization that now mum and dad no longer live together and we don't have that support that we previously had, whether that support was in caring for the child or making the money or paying for expenses, or whether the support was, well, look, you just had an extra pair of hands to be able to assist you with that care. You don't have that when you go through that separation, but then leaving your child with the other parent, no matter how hands-on they were, it's not an easy decision for any parent to make. So in parenting matters, obviously, when you put in considerable effort to actually, being able to enter into parenting agreements, whether you do it through a parenting plan or through consent orders, it takes a lot of effort for parents to actually, in some cases, get to a situation where they're basically leaving the child with the other parent, and then they might not feel as comfortable or as confident in doing so. So a lot of time in situations like that, you do get a parent come up to you and say, hey, look, even though we've agreed on that settlement, I've gone and spoken to the child, and the child doesn't want to comply with those orders or doesn't want to see the other party or whatever the issue might be. But then you realize that the child is 5 years old or the child is 7 years old. And then a lot of those times you actually have to explain to your clients that firstly, that's not something that the law allows you to do, legally speaking, allowed to discuss these proceedings with your children. And I
Yeah.
understand it can get very tricky for a lot of people, a lot of lay people to actually comprehend that in a sense that, look, how can I not go and talk to my child about this? But these orders affect my child. And then it's a balancing act in relation to how you can obviously acknowledge where your clients are coming from, but at the same time explain to them that, look, there's got to be decisions that they're making for the child where the child does not want to do certain things and doesn't want to comply with certain directions given to them by the parents, but you don't let your child just do whatever they feel like doing or whatever they want to do. And then this situation in relation to parenting orders is actually no different. And until there's a risk to a child's safety, and if there is a risk to a child's safety, you would not be entering into consent orders if that is a concern of a parent. But if there's no risk and a child's a healthy, thriving child, it is, generally speaking, good for the child to have a relationship with both the parents. And then you just have to obviously explain to your clients and find a way that they can actually understand where the law comes from, at the same time have their mind at ease. And sometimes it could be that you enter into sub clauses within your consent orders in relation to providing securities or assurances to a parent. For example, if there's a concern that if a party was to repartner, the other party, the other parent needs to be given notice before the children are introduced to that parent. Same goes for relocation, that if a parent was to relocate, X kilometers away from the current residence, if that's going to make it harder for that parent to spend time with the children, then you can have those clauses inserted, but you can't just do it based on what your children say.
And I think there's a real art there to trying to figure out really what is at the heart of the problem and what is creating the roadblock to getting a resolution. And I think that's what a good family lawyer can offer in terms of providing those pathways and removing any blockages from both sides and coming up with a good comprehensive set of orders that both parties are able to realistically live by and follow. And that's essentially what you get when you get a good family lawyer, I guess. So,
And I
yeah.
think that is, just to add to that, I think that's a very important, crucial first step, because a lot of the time we have had clients who've been to 1, 2, 3 different solicitors and they just weren't getting the right advice. You can't blame them to try and go with someone who they thought was a lot more cost effective as compared to some other lawyers. But then you have to be very careful as to who you choose as your solicitor and how you actually end up connecting with them. Because I always say to my clients, the law is the same. A lot of lawyers would know the law, but it's about making sure you have that connection and you actually have that confidence in your lawyer, because a lot of the time that goes a long way as well. And especially in tricky situations like these ones that we're discussing, if you don't have confidence in your lawyer, it'll be very hard for you to actually make those decisions in full
Absolutely.
confidence.
Absolutely. Great point to finish on, Harpreet. Thank you very much for your time today, and wish you all the success for your future cases.
Thank you, Heather. Thank you for having me again. Have a good day.